Okay.
Good.
Okay. All right. So, hi, good afternoon, everybody, and Happy New Year. I'm real quick just before the presentation gets started. My name is Kelly Garver. I am the Business Development and Marketing Manager with Sterk Family Law Group. And thank you, Senior Services of Will County, for inviting us today and the partnership we have with you as one of our resources. So with Sterk Family Law Group, we have a little bit of different approach to both family law and estate planning, is that we believe in the power of the community by working with various resources like the senior services to be able to assist our clients and their families with different areas within the community that can help support them in different areas of their lives. So today with us, I've got attorney Gwendolyn Sterk, who is the owner of our firm here, as well as attorney Terry Fogarty. Gwen's gonna, I'm gonna have her go ahead and just kind of introduce herself real quick, because she does have a client engagement this afternoon, so she can't stay on too long. But Terry is the attorney within our firm who is the estate planning attorney. So he knows the ins and outs of who, what, where's, and why of estate planning. So we'll have him go ahead and do that. So.
Very good. Well, thanks for having our firm out today. You know, we believe that knowledge is power, and if we can share information that we have, once somebody gets the information, then they have it and they're empowered to act on it as they need to do so. And I think that it's easy, and what I've seen is practicing more than 30 years in the area of family law, and now we've added estate planning into our firm, is we have seen a significant amount of people that just simply don't take the time to take care of business. You know, it might be that thing that becomes a very simple solution and it can solve a lot of your problems, but you don't pre-plan, or you wait until there's a crisis in order for something to be done. And certainly help can be made in those crisis times, but sometimes it gets complicated. So our mission is to share our information that we have and to do a series of educational material and presentations so that you can learn more about what things need to be thought about. So Terry, today I know that you're going to talk about the wills and how to do the wills, but I had some, you know, and I am going to have to leave early because of a client engagement, but there are some things that I think are frequently asked questions that I see even in family law. And so I know we're not going to address them at this time, but throughout the presentation, if you can keep these in mind. You know, I don't have a will, or I wrote one up 35, 40 years ago. Can I change it? So that's one of the questions. Can I change it, and how do I go about doing it? Another common question we get or statement is, listen, I don't have any money left. I've been through my retirement. I've sold my house. I'm X, Y, or Z. I don't have enough money to make a will a necessary item. How do you address that issue? Next thing is, what's the difference between a power of attorney and a will? Because I know that I need somebody to help care for me. I know I can't do certain things anymore, but how is that different from my will? And is there a difference? And if so, what should I do about it? And then the last one is, and it's a common question, and I have a 91-year-old mother, so she said to me the other day, shouldn't I just give everything away? And I'm like, well, what are you going to eat on? She was talking about her personal property. Because is it better to give away my property now, or my money now, or should I keep it and hold on to it so that I can do some good planning? So Terry, I know these are common questions that people have across the board, and I know that you're going to cover all that material, but those were some just follow-up questions that I think I'm seeing on a regular basis. So I'm going to turn the program over to you. Thanks, Terry, for doing this. We really appreciate it.
All right, thanks, Gwen. Can everybody hear me okay?
Mm-hmm.
Very good.
Yep.
All right, great. So my name's Terry Fogarty. As Kelly and Gwen stated, I am the attorney at Sterk Family Law that handles basically all of the estate planning and probate issues. Just to give you a little bit of background, I was actually in the Air Force when I decided to go to law school. I went to law school in Washington, D.C. And moved back here where I'm from, the south side of Chicago. I live in Palos Park with my family. And I basically concentrate on real estate and estate planning. Those are the two areas that take up about 98% of my time. And I'm very happy doing them. I love, used to work in litigation, and basically what would happen is whenever anybody left, nobody was happy. No one on either side was happy. But with estate planning and with real estate, basically everyone's happy. Everybody gets something that they need, which makes me happy. So I'm going to get started today. Basically, my presentation today is it's it's a topic that can be talked about very simply and straightforwardly, or we can actually get into a little bit more detail on a will. And that's what I want to do for you today. So I'm going to start with just kind of giving you an overview of what a will is and what it does. A will is also generally called your last will and testament. And it's called that because it is a legal document. So it's a legal statement by you that expresses your wishes as to how your property will be distributed upon your death. It appoints the person who's going to be responsible for handling your affairs after you've died. And it also allows you to name who you would want to care for any minor children that you might have when you pass away. And that's very important. So let's just kind of go right into what's in a will. This is kind of the kind of technical part of it, but I just want to give you an idea of what you can expect when you take a look at a will, what information is going to be there. Basically, the information that's required in a will, it's going to have your name and your address. It's going to have your family information. For example, your spouse and your children will be listed. It's going to state who you want to handle your affairs after your death. That's known as the executor. And we'll talk about that a little bit more in a little bit more detail later on. As we talked about before, if you've got minor children, you can designate who you want to act as your children's guardian after you've passed away. This is something that a lot of younger people don't ever think about. So if you have young relatives who have children or are about to have children, you really should urge them to get their will taken care of, because otherwise, if you don't have this, somebody who has no familiarity with the family is going to make those decisions, namely a judge. So that allows you to designate who would be the guardian of the children. And of course, the biggest thing that we all know a will for is the will is going to designate what you want done with your property. And I'm going to go into a little bit more detail on that later. But first, I just want to talk about some of the legal requirements for a will to be valid. There's not many. Frankly, at a minimum in Illinois, for a will to be valid, the person who's creating the will has to be 18 years old, excuse me. The creator of the will must be of sound mind and have the mental capacity to understand the consequences of their actions. That's very important, because obviously somebody cannot sign a will designating what they want to happen to their property if they don't have the ability to understand what they're signing. And then the will has to be signed by the creator in the presence of at least 2 witnesses who must also sign the will at the same time. In other words, those people all have to be in the same room. The witnesses have to watch the signer sign the document, and then they attest that they watched the signer sign the document. Those are the minimum requirements. When I create a will for somebody, I generally take it a step further. First thing that I add is I have the will notarized as well, all the signatures, so that the creator of the will signature is notarized, and both of the witnesses. The other thing that I always add is you always want to have the pages numbered. This prevents somebody from pulling a page out of the will and sticking one in, or just adding a page to the will with some changes. And then I also generally will add a signature line to each page. Again, that's just a safeguard so that nobody can change the will without your knowledge. So just a few things that I like to add that help to safeguard things a bit more. So we talked about what's in a will, and we're going to get to the heart of the matter here in just a minute, as far as giving away your items. But let's talk about how this will has any effect. So we talked about the fact that you appoint an executor, and this executor is the person who's supposed to wrap up your affairs for you. But they just pull out the will and say, "Look, I'm the executor." It's a document listing all these names. How does it follow the will and work together? Yeah, they're supposed to. How about now? All right.
Yeah, Terry, I think for some reason
start breaking. Yeah, I don't know what the problem is, but so how is a will enforced? Who has the final say? What if people disagree? Yeah. Can you hear me, Cal?
Yeah, sorry, you got like it got hung up and then it like all spit out real quick, so I might have to go back and repeat it a little bit.
Yeah, I'm gonna move my phone around a little too. Let me know if it happens again, please, because
Okay.
usually doesn't happen to me in my office here. But let's see, where were we? So how does a will have any effect, right? We've got this executor who's been appointed by the will. You've made everything that you want, all of your wishes known in your will. But what happens? Does everybody just take the word of the executor? How is it enforced? Who has the final say? What if people disagree? Well, as I stated before in the introduction, a will is a legal document. It's given its force through the laws of the state and through the court process called probate. So on its face, a will really has no legal authority. I do get calls from people a lot who say, I have a will and my sister's not doing what my mom wanted. I have my mom's will. My sister's not doing what my mom wanted. I'm the executor. What do I do? And the first question I ask is, did you file a will? Because a will technically has no effect unless it's filed with the court. So very simply put, this probate process is the process by which the court validates the will. It ensures the debts are paid of the estate, and then it validates the distribution of your property according to your wishes. Now, this process, that's a very simple explanation of the process. Generally, the executor will hire an attorney to assist in that process because usually there's a lot of technical requirements and things that need to be filed, in a certain manner, in a certain format. So people benefit from having the help of an attorney. I'm not saying you can't do it on your own, but it's a lot easier with the help of an attorney. So let's talk about what a will can do and what a will is generally there to do. So the first thing we'll talk about is appointing a guardian of minor children. And I kind of already went over this, so I won't beat a dead horse, but it's very important for you to appoint a guardian for any minor children so that if anything does happen to you, you've had a say in who's going to take care of your kids. There's a lot of things to take into account, such as your relationship, their ability to care for the child, their financial, abilities, et cetera, et cetera. But probably the most important thing to do is to have a discussion with that person, just to know, so that they know that you want them to be the guardian of their child, and that they agree to do so. Because frankly, you could get to court after somebody has passed away, and that person could say, "No, I can't do it. I just don't have the means to take care of another child." So it's important to talk to them about it. It's also always a good idea to have several backups for this. So you don't have to only appoint one guardian for minor children. You can appoint, a list of 5, and they can go down the list if one person's unable to serve. The next thing you'll do is appoint an executor. And this is another very important decision to make because the executor's job is to handle all of the affairs of the individual once they've passed away. And that's not just limited to handing out their property. A lot of people think that's all I've got to do. I'll go over to, my grandmother's house or my mother's house, gather up all the items. We'll all get together and I'll give everything away. But honestly, the executor does a bit more than that. They gather all of the assets and they safeguard those assets during the probate process. They ascertain all of the legal debts or obligations of the deceased and determine which ones need to be satisfied. Once the debts are paid, then and only then can the executor release any funds to any heirs or any assets to any heirs. So the executor does have a responsibility not only to the estate, but also to the heirs to safeguard that property. And I myself have heard of a lot of stories and been involved in several cases where, items have simply disappeared because an executor was chosen who really shouldn't have been chosen and really wasn't very trustworthy. So it's very important to choose somebody who is responsible. There's not too much that Illinois law says has to be, a requirement for being an executor. The person has to be 18 years old. They have to be a U.S. resident. They have to be of sound mind, which is a very subjective term, right? And this is in the law, of sound mind. So you can imagine people arguing that. And they can't have any felony convictions. So the court's not going to give somebody the ability, the dominion over somebody's assets if they've been convicted over a felony. And So as I said, you want to choose somebody who is trustworthy and responsible. It can be somebody who is an heir, so it doesn't have to be a separate party. It can be someone who's an heir. And one other thing to remember for an executor is you can state that your executor is either entitled to compensation for being the executor, or you can state that they're not. So if you're choosing your eldest child as the executor because they're responsible and they're also going to inherit a large amount of money, maybe they shouldn't be paid for it because you're already doing enough for them. So the third thing that your will do is it will state where you want your assets to go. And kind of going over every way that you can do this is a bit beyond the scope of the talk, but it can be as simple as stating that all your property goes to your spouse or all your property goes to your children. It can be as simple as stating somebody gets X percentage and another person gets Y percentage. Or it can be as detailed as going through your assets on an asset by asset basis, down to the smallest items and listing out exactly who gets what. The main thing to remember is that in the probate process, the debts of the deceased person, viable debts, have to be paid first. So a lot of times people will try and leave assets to certain people, and folks will get less than they originally thought they were going to because there were certain debts that needed to be paid. And you can kind of go through exactly what debts are going to be paid by who. If somebody's getting a house, are they responsible for paying the rest of the mortgage, or should the mortgage be paid out of the rest of the assets? Things like that are all questions that should be addressed with your attorney so that everything is spelled out and there are no questions. The debts that need to be paid out of a probate estate are kind of just a little bit beyond the scope of the discussion, but it's important to know that there are certain debts that do have to be paid by an estate. Medical debts are probably the biggest one. The medical debts, you'll always hear the executor of an estate, or usually the spouse or other relatives, will be contacted immediately after somebody passes away, and they're the medical bills wanting to get paid. The probate process includes a means of notifying creditors. Creditors that you know of will be notified right away. They will receive actual notice when you put them on a list and your attorney sends out notification. But there's also a means of notifying creditors by publication, which basically means that you put, generally they're all online now, but you publish the fact that an estate has been opened in someone's name, that they've passed away, on a board online, where creditors go and they check. And then if they have a claim, they'll file it. And so this has to be done for 6 months, which is usually the main cause of delay in getting a probate case wrapped up quickly. But the positive side to this is that once this is done and all creditors have been notified and you've put notice out there and the probate case finally gets closed, then the creditors who may still be out there and didn't contact the court and didn't file a claim, their claims generally go away. So they can't bother the heirs and say, you owe us money because you inherited from this estate and the estate owed us money. So that's one of the main purposes of probate, is to help to stop any other claims on the estate. So that's the other thing that you'll do. You'll state where your assets want to go and who you want to get your assets. And this is what everybody thinks of when they think about drafting a will. One other thing that you can do in a will, and some people do this, I've had several clients recently do this, is you can disinherit someone. You can have 4 children and only want to leave things to 3 children. It's done a lot. People do have falling out with their family members. And you do this in a couple of ways. You can just completely leave them out of the will, but that's not really advised, because then they have an argument that you just kind of forgot about them. So usually what people will do is they'll either disinherit them directly and state, I know that I have another son and I choose not to leave him anything, or they'll leave a nominal amount, let's say $10. I'm leaving $10 to Jim and the rest of my kids are splitting everything. So you can disinherit people within a will. So we talked about what you can do in a will. Let's talk about what you generally cannot do in a will. If you think about it, the main goal of the state and the main goal of the probate courts is to close out somebody's estate as quickly as possible, get the debts paid, and get the heirs their portion of the assets as quickly as they can and as efficiently as they can. So they want to simplify the procedure of settling the estate, paying the bills, and transferring the property. So there's certain things that the state and the court would view as contrary to that goal. So they really don't like to see them in a will, and they generally won't enforce them. Number one, right off the top of my head, is anything illegal. They're not going to let you put anything illegal in a will or leave money to any type of illegal cause. Another thing is a condition to a bequest. You're generally free in most of the states in the U.S. to put conditions on somebody getting your property. But if the court believes that they wouldn't be able to enforce a certain condition, or it's against public policy, or it's logistically just unfeasible, there are many conditions that courts will not enforce. And just to give you a short example of this, and you can think about any other ones. If somebody, let's say somebody leaves their granddaughter $50,000 if she graduates from a 4-year university, but their granddaughter is, and this is in their will, but their granddaughter is 5 years old at the time of their death. Well, the court's not going to keep the probate case open for 20 years to monitor this and see if the daughter goes to school. So the courts wouldn't want to see something like that in a will. They would much prefer that conditional bequests are handled through another type of document, which is called a trust. In a trust, you can do any type of conditions that you'd like to do. And I'll talk about a trust a little bit more, but it's kind of beyond the scope of this. The other thing you cannot do in a will, and it's important to make this distinction, is you can't change any accounts that are pay on death accounts. So think of those as insurance accounts, anything where you've designated, the beneficiary already via their form. So if you try to change a pay on death benefit, it would not be valid.
They have customized solutions for families with special needs. Well done. My safe fireside on track for retirement. Giving us confidence in our future.
All right, so you can't do that. If you want to change, a lot of people, I do have people that think that it does that. You get a call and they say, well, I want my kids to split everything. And we go through the will and we take care of everything. And then, at the last minute, they'll say, now this includes my insurance, right? Because right now only my first son is on it, and it's a $500,000 policy. And the answer to that is no. If you want to change those pay on death beneficiaries, you have to change them at the source. So you have to get the actual documents from that institution and make those changes, because those assets generally do not go through probate. They wouldn't be included as part of the estate. And one other thing, just kind of lightheartedly, Illinois does not allow you to leave money or assets directly to your pets via a will. Believe it or not, you can do this in a trust. There are people that have done it, and there are people that still like to do it. You can provide for the care of your pet by opening a trust account and having somebody else, take care of your pet that way. But because a pet is not considered a person under Illinois law, you can't leave money directly to them in a will. So that's, I found that kind of interesting. I should.
Well, Terry, can you, in a will, because if you can't leave it to a pet, because that person, can you leave it if you wanted to do a donation to a not-for-profit instead of a beneficiary? Can you do that in a will, or does that have to go through a trust?
Oh, no, definitely. Yeah, you can definitely leave charitable contributions in a will, through a will. Okay. That's no problem at all. So we kind of talked about the ins and outs, and I apologize if we got a little too technical, but let's talk about who needs a will. As Gwen said, prior to her leaving, one of the most common questions that we get is, don't have anything. Froze again? Am I back?
It seems like it. Happy Monday.
Good. Yeah, happy Zoom. So who needs a will? So one of the most common questions that we get is, who needs a will? I don't have anything. I don't have enough assets. Why should I even bother putting together a will? Or, my kids know what they're going to do with the property when I pass away, and they're going to get it. So why do I need to do a will? Well, the short answer is that really everyone should have a will. We already talked about the minor children issue. I'm not going to beat that one again, but we know that anyone with minor children should have a will, or else they're not going to know who's going to be taking care of their kids if something horrible happens. If you don't have a will, the state of Illinois has a will for you. And I can tell you, I can, anybody that wants it, I can send you a copy of the, this is the will of John Doe, written for him by the state of Illinois, that I have. And it's generally not what you think. Most people think that it's just going to go right down the line, right? If I pass away, it'll all go to my spouse. Technically, if I were to pass away without a will, half of my property will go to my spouse and half would go to my 5 children, several of which are underage. So a lot of people don't know that. A lot of people don't know that the intestacy laws are a lot different than they think they are. Intestacy means dying without a will. It's usually not what people would want and not what people would expect. Also, if you don't have a will, you don't get the opportunity to appoint the executor that you would choose, the person that you want to wrap up your affairs. Dying without a will, you basically, this is the difference. You may have heard the term executor versus the term administrator. The executor is the executor of an estate where a will has been written, accepted, and has been filed. An administrator is somebody who has filed to administer the estate of somebody who does not have a will. So obviously the person without the will didn't designate that administrator, right? There was no way to designate them. So that administrator is anybody who can show that they have any interest in the estate. So you don't get to appoint your own executor if you don't have a will. Obviously, there are instances where somebody has very little property and probably doesn't even need a will. And frankly, their will might never even come into play. I'm going to be the first to admit that. There are times when somebody asks me, do I need to probate this will? And I say, well, I don't see any reason why you should. Grandma had a box of stuff in the basement and she was living with you. I don't think there's going to be a problem with that. But the problem is you really won't know if you're going to run into any issues with an asset until it's too late. I did have a client years ago who had a trust, which basically is another way of giving all your assets away according to the terms of the trust. And what happened was he had just sold about $50,000 worth of stock. And so it was taken out of the trust and put in his name in a bank account because he told his accountant he was going to, figure out what to do with it. He was going to invest it in something else. Well, he passed away and his accountant had put it into an account that was only in his name and not his wife's name. So she had a hard time getting to it. And that's where his will came into play because it was outside of the trust. Now, I know you're thinking, well, I don't have a $50,000 account. Well, true. But, a lot of times those things can come into play on the smallest items.
You froze
Real estate
again.
is one big issue. It can be very tricky.
Can't hear you.
Comes back. Can you now?
Can't hear you.
How about now? How about now?
Yep.
All right, I'm just going to hold it here. So obviously, there are instances when some folks just really might not need to invoke their will, but that really doesn't mean they shouldn't have a will. The will is going to be that fail-safe that comes into play when that asset is found that nobody knew about. Real estate is one big one. Real estate, you will always want to have a will, or possibly even put that real estate in a trust so that it passes very easily. Otherwise, you definitely have to open a probate case if there's real estate involved. There's just no way going around it. So you're better off having a will so that you can have some form of control over who's taking care of the process. You'd also be surprised, and I'm surprised, frankly, at how often we get calls, or I get calls, about siblings on very small estates who simply cannot agree on what's going on. Usually there's a sibling who is out of state and she's calling because she doesn't feel that her sister, or he's calling because he doesn't feel that her sister is doing a very good job and is being forthright and forthcoming in the whole process. Now, a will is going to help immensely with that, because you're going to be able to avoid a lot of those issues. You can, very simply, a will generally state, look, my personal belongings will go to whoever wants them. They get to decide amongst themselves. If they can't decide, then the item's going to get sold and they split whatever the cost is. And that's it. So it can clear up a lot of those issues as well. Now, another thing that Gwen had brought up prior to her leaving was a power of attorney. So let's just go over real quick exactly what a power of attorney is, and is it a replacement for a will? So a power of attorney is a document, and generally there's two types of power of attorney. There's a power of attorney for healthcare, which is going to allow somebody to make healthcare decisions for you if you can't make them on your own. And there's a power of attorney for property. And the power of attorney for property, an unlimited power of attorney for property, generally lets somebody make property decisions for you. And money is property, so they do have basic control over all of your assets. And I get the question a lot, my daughter or my son has power of attorney for me. They know what I want to do with my property. So why do I need to draft a will? They can just handle everything once I'm gone. And the short answer is no, they cannot, because a power of attorney for property technically is only good while the grantor is alive. So when you pass away, technically that power of attorney is no longer any good. Just to give you an example of that, my uncle passed away a couple of years ago, and my father was his power of attorney. And one of the first things he did was reach out to the bank where my uncle had his accounts and send them the death certificate, and then followed up with, I'm power of attorney, I need all this information. And they called him back and told him he was no longer power of attorney because the power of attorney terminated upon my uncle's death.
Wow.
Yeah. And my dad called me and wanted to know what was going on, and if I could call these people and tell them they're wrong. And I said, I'm sorry, Dad, but they're right. So we ended up, he had to wait until he got, until we filed, and we were in probate, and then he got letters that allowed him to go and talk to the bank. But so a lot of people don't understand that a power of attorney does terminate on death, and it's really not it's just not a substitute for a will. And I'll take it a step further. I know we haven't really talked about trust too much, but a trust, like I said, is just another document that allows you to avoid probate, first of all, because it takes it out of the court's hands. But even folks who have a trust, which is considered a more advanced type of estate planning than a will, still have a will. They have what's
Out again, Terry.
called a
Terry.
backup will, and that will is there.
Yeah, we lost
I
everything.
lift it up a little. How's that?
Nope.
Anyone?
Nope.
Got your audio.
Nope.
Oh, well, that's
Reporting that you have a low bandwidth, low network bandwidth, which is causing the garbled audio.
Oh, that should not be happening.
Well, while he's taking a technical break, so Terry, we can answer a couple of questions about the difference between a trust and a will, but we will be back on February 19th to go into more details about trusts and the different types of trusts that are available. But today we just wanted to kind of just answer a couple of these questions about the differences. So if you may have, if you're making your planning here.
Where is this law firm located?
We are in Orland Park near 183rd and Wolf Road, but we practice in Will, Cook, and DuPage counties. And obviously, I know we talked at the beginning of this due to the pandemic. We are doing things remotely, so we do offer free, no obligation consultations. So if you were looking for it, we can either set it up via Zoom or via phone as well.
You have to give us some contact info.
Yes, I will. I will go ahead and I can put that in the chat, and then I know that the senior services has it, but I could be happy to email anything out to you too. Yes. Let's see, I think he might. Let me just excuse me for 1 second. I might try to give him the call-in number to see if that'll work for him. I'm just trying to get him the call-in information. Again, I'm not an attorney, but if there's any, and we can, if you've got any questions about everything that we're going on here, we can, if you'd like a brochure or more information, I'd be happy to send that to you directly. Maybe Mary, if somebody has any questions and they reach out, you can let me know and I can handle getting that. Oh, there he is. Handle getting that over to them. You're muted, Terry.
Yes, I'm back. Can you see me now?
Yep.
Yep.
Oh, good. I apologize. I do this every day and I normally don't have any issues on Zoom, but you know, it's pretty typical.
You know what? The world's made us all a little bit more adaptable, so we just got to roll with it.
Good. All right. So I think we've kind of addressed, you know, the powers of attorney portion of it, why that's not really a good, you know, good substitution. And I think the last topic that I was talking about was the fact that even folks who have very intricate trusts set up still have a will just in case. That will acts as a safety net that will catch any other items that might fall outside of that trust. And you know, anything else that they might have just missed. Some folks will inherit property in another state and forget about it after 20 years and just not realize what they've got. And some folks will underestimate the amount that they have. So let me just talk about real quick, who cannot make a will? And this sounds like a funny issue, but there's a reason for it. So we touched on it a little bit more, and generally a person can't make a will if they're under the age of 18. And if they don't have the mental capacity to understand the consequences of their actions. And you'd be very surprised if, you know, by the amount of people that call me and they explain to me, you know, my mother's been going downhill for a while now. She has dementia and I just realized she doesn't have a will. Can you make a will for her? Or I get a call that says my mother has dementia. She's been living with me for 3 years and she wants to change her will so that I get everything instead of my siblings because I've been taking care of her for 3 years. And we run into a problem there because if an individual is not able to comprehend what they're doing and what they're signing, and they don't understand the repercussions of their actions, they really cannot execute a will. So, you know, I just wanted to give that as an example. It's a very good idea to get a will and get your estate plan in place sooner rather than later, because it makes it much more difficult. Sometimes you'd have to get, you know, possibly get a physician to actually draft something that says they are of, you know, they were of sound mind and capable of comprehending what they were doing when they signed the document. And even then it opens up the will for some possible challenges later on. So it is always recommended to get that done sooner rather than later. Gwen had also touched on having a will reviewed or having your estate plan reviewed and how often that should be done. In my opinion, you really should review your estate plan and your will every couple of years, every 5 years at the most, honestly. And really, whenever you have any type of major life-changing event, you should review your estate plan. You know, getting married or somebody else in your family gets married, having children or somebody else in your family has a child who may possibly be listed in your will as a beneficiary, you might want to make certain updates. Somebody passes away in your family. Possibly they were listed as one of your executors or the guardian of one of your children, and you might just have to update those things. Now, most attorneys will probably want to redraft your will at that point. It's always a good idea to redraft the will, but it doesn't have to always be redrafted. You can do what is called a codicil to a will, which basically, excuse me, is just a written statement that says, I'm making this one small change to the will, but the rest of the will is in full force and effect. I would always suggest that you still go to an attorney to accomplish this, because there is specific wording that has to be in that codicil that will guarantee that it's accepted by the courts. So I got a question about, just really quickly, a question about only needing to go through probate if the estate, the value of an estate is over $100,000. And yes, that's true, but there are some caveats. So generally, there can't be any real estate. Even if the real estate's only worth $15,000, it still would have to go through probate. If you do own property and it's under $100,000, there's what's called it's basically an abbreviated probate procedure where you just simply file the will, they issue you letters of administration, and you handle things that way. So that is an option. It's called a small estate affidavit.
All right, and Terry, there were a couple other questions you might have not seen. Teresa asked, does your executor or any heirs have any responsibility to pay your debts if your assets are not enough to cover your debt?
No, definitely not. And that's kind of the whole point in one of the whole points of the probate process is to really cut off any debtors, creditors, I'm sorry, from calling you, from calling your heirs. And believe me, it happens all the time. When I first started out as an attorney, I worked in debt collection, and I would go to certain conferences where there were people with booths set up that would say, we will not only search your deceased person, but we will find them family members so that you can call them as well and try to collect from them. So there are people out there who are unscrupulous and will try to insist that you owe money. When my father-in-law passed away, in fact, we went down to Alabama to close out his bank account, and he was overdrawn by a couple of $100, and they asked me how I wanted to pay for that. And I kind of looked at him and said, I don't, and I'm not going to, because it wasn't my responsibility to do so. So the answer to that is a big no. If there is not enough money in the account, in the estate, you do not have to pay any of the bills.
And then it looks like someone else, Jeff, asked a question. Can you explain some of the key documents of an estate plan? There's a trust, pour over will, healthcare directive, power of attorney for healthcare, power of attorney for property, and what else?
What else? So basically, the other major document that is generally included in a comprehensive, what I would call a comprehensive estate plan that covers all your bases, would simply be a directive. So the directive is basically that do not resuscitate order, right? So that you can specify what you want done at end of life for end of life care. Otherwise, we pretty much got all the other bases covered. Now, I'm not saying you have to have a trust, but if you do have the desire to have a trust and have a little bit more control over what's happening with your assets, or you do have more assets and you think that you would benefit from a trust, then yes, a true comprehensive estate plan would definitely include a trust, a will, powers of attorney for both property and healthcare, and that directive, that medical directive.
Okay, so I know, Terry, we're going to be in February talking about trusts, and what part of the estate plan would, because we're in March, we're going to be talking about guardianships. Would a guardianship fall under?
So a guardianship is kind of a strange animal in that it really doesn't fall under the estate planning, because Well, let me put it to you this way. Guardianship is the process by which the court appoints a guardian over somebody, over either their person or their estate. So a guardianship of the person basically says, this person cannot take care of themselves, so they need a third party to take care of them. And a guardianship over the estate says that this person cannot handle their financial affairs, so this person needs somebody to do that. There are ways to prevent a guardianship from being necessary. One way is to have powers of attorney for property and powers of attorney for healthcare in place. If you kind of see the correlation there, power of attorney for property and healthcare, you're giving somebody else the ability to make those decisions for you. So you can avoid having to go through the cost of guardianship, because guardianship is really a last resort process used by the court when somebody really has no means of actually taking care of themselves. And it can be very costly, first of all, to instate, because you have to pay for physicians' reports. Oftentimes, the court will appoint a lawyer on the side of the person you're trying to be guardian of, and they will have to be paid. You have to file yearly fees. You have to file yearly accountings and reports. So honestly, if you can get a comprehensive estate plan in place with powers of attorney for property and powers of attorney for healthcare, it is possible to avoid ever having to go through the court and get a guardianship.
So, and then there was another question here from a Joe Melfi. Does the court start with probate review by the court, or does everything start with probate review by the court and then the court decides the trust and will can be executed?
So a trust is going to fall outside of the court's jurisdiction. A trust is not a document that has to be validated like a will does. A trust is, so a will is created under the probate law. Trust is created under the trust law. They're similar because a trust is also is often used in estate planning, but they're not the same. So a trust does not have to go through the court system at all. It doesn't have to be approved by a judge. It can be challenged in the court system. So if somebody disagrees with what somebody's put in a trust, they can challenge it. But quite frankly, the judge is going to look at the trust and interpret it the way that the trust drafter, wrote it. So a trust is, and as Kelly said, we'll get into a trust later on. And really go into the benefits of a trust and all the things that the trust allows you to do. But a trust will stay out of probate court. A will definitely has to go through probate court because, frankly, it just doesn't have any authority until it does go through that process.
Then there is, I think, Joe Melfi again, the document that allows family members to discuss healthcare with the doctor. I think we touched with that being the power of attorney and the advanced directives.
Yeah, so that's the HIPAA authorization.
Mm-hmm.
And as long as if you're using the standard Illinois healthcare power of attorney, it does have that included in it. I always include it for my clients as well, just in case maybe they're out of state when something happens. So you've got that HIPAA compliance. So they do have the ability to look at your medical records and discuss with the doctor, what's going on. But it is included in the Illinois statutory power of attorney. So it does have that section in there that says, I also authorize this person to discuss my, with my doctor and to view my medical records.
Very good. All right. Does anybody who may not be in the able to type in the chat have any questions for Terry?
How do you go about getting this HIPAA authorization?
So the HIPAA authorization, you could look it up online if you wanted to get it done online, or any attorney would be able to prepare it for you. An estate planning attorney would have access to all those documents.
Okay, thank you.
Sure.
I have a question.
Mm-hmm.
You mentioned paying off the mortgage from the estate in a relatively simple will where the executor is my son, he's my only child, he gets everything. I have a good deal of equity in my house. Is there any advantage to having the house paid off from the estate rather than him as executor just selling the house. And, there's going to be equity on the table. It's not like it's in the red. So is there any advantage? It seems to me just an extra step to have the estate pay off the mortgage first.
Yeah, in that case, if he was the only person who was going to be benefiting, it would be an extra step. I think in my context, I was kind of alluding to if there were several people who would be inheriting, but you wanted to make sure that that house was paid off, at the time, because you wanted the person to get it free and clear. But in his case, yeah, I think it would just be an extra step.
Yeah, great. Thank you.
Sure.
All right. So what I'm going to do for everybody here, and again, Mary, I know the senior service has our information on hand. I'm going to drop our website, phone number, and everything in the chat box here. And then I'm also going to put a link. I know this is a lot of information to take in, and if you guys have any questions, again, please, we offer free no obligation consultations. So if you've got a plan put together, you're looking at creating one, your family does, please give us a call and we'd be happy to set something up to talk to you in a little bit more detail on a one-to-one basis. And if we also put a book together, which I'm putting a link in, about navigating the winding road. There's a couple of very detailed chapters about estate planning that Terry put together in there too, that could be a helpful tool. But if you guys, again, have any questions, you think of something later on, you want to set up a consult, please give our office a call or visit us on the website. We're also on Facebook and Instagram and all over the place too. We've got a lot of videos on our YouTube channel too, if you want to watch a couple of additional things about this. And then otherwise, we will be back, I believe, on February 19th to go in more details about a trust and the different types of trusts in part of your estate plan. And then again on March about protecting yourselves and loved ones through a guardian. So we kind of only touched the iceberg on those today. And again, there's a lot of information here. So if you go sitting back and digesting it later to any questions, please feel free to give us a call.
Thank you.
Thank you so much.
Thank you.
Thank you, everybody. And thank you for
you.
dealing with our technology hiccups here, but we've all been there at some point.
Oh, yeah. It happens.
Yep. But at least this is giving us the opportunity so we can meet and talk with everybody. So thankfully
It
this
does. Thank you.
Yeah. All right.
Any other questions from anyone?
I have a late question. If you're still open to questions,
Sure.
who should hold the will and should there be copies? You mentioned in your talk that a will is no good unless it's presented to probate, I think. But, before I die, who should hold the will and should there be copies? And I guess the subpart question is, if my son is the sole heir and beneficiary, should he hold the will?
That's a good question. I would say if your son is the sole beneficiary and heir and you trust him to not lose the original will, then he should hold the will. You should always make copies of the will just so that you have, at least one or two copies in case the original is lost. The court prefers the original, and there are extra steps that you have to take if the original is not filed with the court. So you always want to make sure somebody knows where the original is. I don't necessarily advise you to put your will in a safety deposit box unless you are 100% certain that somebody else has access to it and knows it's there. Otherwise, they need the will to get access to your safety deposit box, and they can't get the will because it's in your safety deposit box. So that can be a problem. But just make sure that your will is either kept with somebody that you trust, or it's kept somewhere safe and that other people know where to find it. Because I do also get a lot of calls from people who say, I'm sure my mother had a will, but nobody can find it. So what do I do? So just make sure somebody knows where it is.
Thank you.
Sure.
Hey, I can. Well, thank you guys, everybody here very much. And thank you, Senior Services of Will County, for having us. Again, if you have any questions, my information's in the chat, and please don't hesitate to reach out to us if you have any questions at any time.
Thank you.
We did record this, so I did just put my email down in the bottom there in the chat box too. If any of you want the recording, you can email me. I can send the link to you as well.
And then, if Mary, if you could send me a link of it,
Oh, I
I'd
will.
be happy to put it. I could put it on our YouTube and tag you guys, so you guys could have it too.
Okay. I will do that.
All right. Well, thank you very much.
Thank you. Thank you,
Thanks,
everyone.
everybody. Have a great night.
You as well. Thank you.
Happy New Year.
Thank you.
You too.